right, number 13 is Sushant Gupta versus Leanne DeSalvo.
Yes, good morning, Your Honor. This is Sushant Gupta here.
Good morning, Your Honor. Christopher Brainerd on behalf of Kristen Leahy and Leanne DeSalvo, who is present in court with me.
All right, thank you. You may be seated. And Sushant Gupta, is he on the line?
Yes.
Yes, I'm here on the line.
All right. First of all, Mr. Gupta filed a disqualification motion that is a challenge for cause. Counsel, I appreciate your filing a response as if this were a peremptory challenge. It was not, so I did not consider or rely in any way upon what you filed. However, the court does strike the disqualification motion. The ruling, I've posted it also. Secondly, there's an ex parte motion to continue it set for 1:30. I'll advance it to this time. Here, the moving party has failed to make an affirmative showing of irreparable harm, immediate danger, or any other statutory basis for granting relief ex parte. California Rules of Court 3.1202C requires such, and it has not been shown. Now, I will hear the motion deeming the plaintiff a vexatious litigant, which case law describes this court's obligation, really, for the benefit of the public in such cases, to hear motions regarding vexatious litigants, notwithstanding a dismissal of the underlying case by the plaintiff, who is the subject of this proposed order, deeming him vexatious. So with that, the parties have been provided with tentative rulings. Counsel, do you submit on the tentative ruling?
With only one caveat, Your Honor, we just wanted some clarification with regards
Then
to...
I'll wait. I'll let Mr. Gupta then argue. Mr. Gupta, you may argue.
Yes, I do not submit for the tentative rulings. And 5 cases which you have shown in the tentative ruling, the Deutsche Bank and the IndusInd Bank, they were settled. They settled the case with me. They are in India. And all these cases were filed in Orange County. This is my first case in the LA County Court. All cases are in Orange County. And I did not know how this court works. My intention was to file a small claims case, but because the defendant is out of state, I filed a civil lawsuit. And Venmo asked me to file a case against her business as well. And as she is the owner of the property, that's why I filed the case against her. And Venmo has settled the case with me. They have already paid me. Venmo has paid to me already.
Thank you. Thank you. So you're restating your written argument. I understood it when you wrote it, but that's fine. You can say it again. Anything else you wish to add that you did not write?
Yeah, so this 2640 LLC was against my tenant who was here. That was her landlord, and that's why I filed the case, because she was not leaving the property. And then I do have a judgment against my tenant from the court. So I'm not a vexatious litigant. This first case, Deutsche Bank, AG, they are in India, and the IndusInd Bank, they are in India as well. That's one case. IndusInd Bank Limited and Deutsche Bank, that's one case. That's one case. That's not 2 different cases. And then they settled the case with me. I have a settlement from them. That's why I dismissed the case. I'm not a vexatious litigant. All of my cases were filed in good faith.
Thank you. Now, did you had an argument as well?
Yes, Your Honor, thank you. First off, we've just heard plaintiffs say that this is his first ever case. I've got in LA County, and It's just not true. I've got, yes, sir, understood. It's got his phone number on it. With regards to Indusland Bank, those are multiple cases. It's strictly right along the code. We have to take his word for, and it doesn't matter. And he's dismissed this case, which is yet another case that falls right within the statute, and I think you can take judicial notice of the fact because it's your case. So that's a sixth case. One other thing, Your Honor, the one thing I actually wanted to give some argument about, or just a request to point out, is that we just wanted some clarification that he'd be subject to a pre-filing order. In one of his declarations, he says specifically he's going to sue me personally for defamation of character. He may have already filed it, but the intent is here. If I can give it to the judicial assistant for you to take a look at, if need be, we're hoping that he's subject to a pre-filing order so that the presiding judge of whatever county he intends to file in has to give him approval before he does it. Otherwise, we think we'll just be right back in court on this case and on.
I'm not able to understand what he's saying.
You'll have to. Will you repeat what you just said, counsel, into a microphone so that you may be audible?
I'm not able to understand what he's saying,
No,
and
Mr. Gupta, I heard you. I told him to repeat.
Yes, we just want to be sure, Your Honor, that he is subject to a pre-filing order requiring that the presiding judge of whatever county he intends to file in gives approval prior to him filing. In his declaration, dated October 7th, he says he says, Mr. Brainerd is accusing me of forging signatures and also calling my motions trash. I have to file a separate lawsuit against him for defamation of character. On its face, that is meritless and indicates exactly what a vexatious litigant would do. He's also indicated in other declarations that he's going to reopen this case unless we drop this motion, and that's just not appropriate. This is a meritless case. He shouldn't be refiling it, and he shouldn't be threatening to sue me for defamation, and he's going to follow through unless there's a pre-filing order. I think your order thus far is silent as to that. It probably contemplated that you were going to sign and have him be subject to a pre-filing order, but we just want to be clear on that point so that we.
I'm going to look into the procedures. Well, point's well taken, but I'm going to look into the procedure doing that.
The proposed order, Your Honor, is on the last page of the final reply. I prepared it for you for your review.
I see.
On the final reply.
Or anything else, Mr. Gupta?
Yes, I think you are biased towards Mr. Brainerd. I requested the court to change the judge in the matter because I explained everything, and I'm not a vexatious litigant. These cases were filed on merit, and I think this is not justified. Mr. Brainerd has been accusing me of forging the signatures and calling my motions a trash. And that's not justified at all, because I have never forged anyone's signatures. And I think you have previously denied me ex parte, and you have just declared me a vexatious litigant out of no reason. I've given you all the explanations. I think I need to change the judge in the matter.
No, I struck that.
And I also need time to file all of my motions in detail. I have explained it to you that Venmo asked me to file the case against Leanne DeSalvo and her business, and this was filed in good faith. She took money. She did not do anything. I have provided you declarations. This guy, Brainerd, he filed a fake proof of service in the court. You are saying nothing to him. Okay, you are just taking his side. That's not justified. This is my first ever case in the Los Angeles County. I didn't know how it works. This is not
Mr. Gupta.
Declaring me
Stop, Mr. Gupta.
Ask me to post $10,000. I don't have that kind of money.
All right, Mr. Gupta, you're not behaving yourself in court, so I've turned you off. I got to tell you, I call him as I see him. I don't know Mr. Brainerd. I don't know you. All I do is look at the file, read the motions, call him as I see him. the court. I'm going to look into the pre-filing issue, but I'm essentially going to adopt the tentative. I may modify it in that respect. I'm going to look into the right way to do that. So I'm not sure that your order's right, but yeah, I'm not saying it isn't. I just need to check that. Okay. Thank you.
I'll provide notice.
Pardon?
I'll provide notice as a
Yes, thank you.
Thank you, sir.
Hello?
26.
Okay. All right. Next we have
Hello?
2515 Thurman.
Good morning, Your Honor. Whitney Ackerman for, I believe, defendants in this case.
Yes, for the defendant. Yes. And we have Mr. Poulter.
Yes, hello and good morning, Your Honor. Brian Poulter for the plaintiffs.
All right, Mr. Poulter is present, and Mr. Ackerman, you are submitting on behalf of your clients.
Yes, we submit pending argument, Your Honor.
Thank you. All right, Mr. Poulter, you may argue.
Thank you, Judge.
Oh, we have a court reporter on this matter, and it's Ms. Curry?
Yes.
All right, thank you.
Thank you, Judge. And first of all, I just wanted to say thank you for the court's deference in pushing this over to consider the moving papers subject to the last hearing that we had on this matter. I read the court's tentative. There are two specific issues that I would like to argue and be heard on, and I'll try to be as succinct as I can and as efficient as possible to not waste the court's time. The number one issue, or the first issue that I'd like to be heard on and argue, is with respect to notice, and that's specifically Code of Civil Procedure Section 1010. The moving papers the opposition papers indicated that a notice served on the party against whom sanctions is sought must comply with all of the requirements of CCP Section 1010, including the time and place of the motion hearing. Otherwise, it does not satisfy the safe harbor requirement, even if a second notice starting the time and place is served when the motion is filed. And that's Gallery Plus Incorporated versus Hominy Bank, 2009, 179 Calat 4th, 535. And in this specific case, Your Honor, there were a number of issues that are directly on point to the issues that we have in this case. And it starts off specifically with the discussion of whether or not the notice in the 128.7 motion in that case strictly complied with CCP Section 10, and it began with a reading of Section 128.7, subdivision C1, which says that notice of the motion shall be served as provided in Section 1010, but shall not be filed with or presented to the court unless within 21 days after service of the motion or any other period as prescribed by the court may prescribe, the challenge paper, claim, defense, contention, allegation, or denial is not withdrawn or appropriately corrected. There were a few underlying tenets of law that the court made a point to acknowledge, and it says that Section 1010 provides that a notice of a motion must state when it will be made. And it says specifically that a formal notice motion is required to begin the 21-day period, and that strict compliance with the statute's notice provisions serves its remedial purposes and underscores the seriousness of a motion for sanctions. So the point that I'm getting at here is that the initial first motion for sanctions was served on May 31st, 2024. We were under the impression that at that time it had also been filed. The court, in its tentative, noted that it looked at the docket. It appears that it was not filed. That being said, though, however, the notice of motion, again, this idea of strict compliance, the notice of motion in that particular 128.7 motion stated that this matter was going to be heard on July 31st, 2024. So again, we're talking about strict compliance. They served the motion on us. They adequately reserved a hearing date for July 31st, 2024, which means that for the purposes of the 128.7 safe harbor provision, that motion with that reservation, with that hearing date, to strictly comply with Section 1010 needed to be filed with this court on June 21st, 2024, which would have been 21 days later. That was not done. And had it been done, however, and if July 31st, 2024 was no longer available on the court's docket to hear this motion, which was the original reservation, the case law in Galleria Plus Incorporated suggests that the appropriate action to be taken is to file an ex parte application to specially set the hearing for that July 31st, 2024 date. That was not done. So what does that mean in terms of this particular case? It means that it's basically dead on arrival because it does not strictly comply with CCP 1010. And if it does not strictly comply with CCP 1010 with respect to an actual formal notice motion, the 21-day safe harbor provision never begins to run, period. So the court made note in its tentative ruling that they filed their motion 54 days after having served it. However, that's a entirely different reserved hearing date time under CCP 1010, and it effectively would be a second motion that's being filed on its own, separate and apart from the original motion that they had filed. So I pulled some of the Rudder Group commentary. I think it would be helpful for the court to hear because it helped me kind of understand this nuanced issue that, quite frankly, I've never been faced with before. And what it said is this. I found these two comments interesting. It said, some have questioned whether having a hearing date on the originally served motion is necessary, because what is important is giving notice of the date on which the motion will be filed, the last date in the safe harbor period within which the offending document may be withdrawn. But since the statute says the notice must be served as provided in CCP 1010, which requires a hearing date, the safest course is to include the original hearing date and the original notice. And then it goes on to say, as a practice pointer, this assumes that you can set or obtain a hearing date from the court without filing your motion 21 days later. Depending on the procedure for obtaining a hearing date in the court in which your matter is pending, if you are unable to set a hearing date without filing the motion, you may need to make an ex parte request to obtain a hearing date to commence the CCP Section 128.7 procedures. And I think that language there, to commence the 128.7 procedures, is significant. And so going back to the Galleria Plus Inc. versus Hominy Bank case, the issue in that particular case was that a lawsuit was filed, and the defense, in response to the lawsuit, served the plaintiff's lawyer with a 128.7 motion. And it said on the face page and body of the document, it said that the motion would come on for hearing on and after May 23rd, 2008. And then it says on June 13, 2008, respondent served appellant with a motion for sanctions and filed it with the court the same day. Now, the Court of Appeal in that particular case, the contentions at issue were the appellate contends that respondent failed to provide required notice of its motion for sanctions. We agree. Respondent's notice of its motions for sanctions did not meet the requirements of Section 128.7 Subdivision C1 or CCP 1010. This is similar and akin to the issue in Gallery because the original hearing date that was noticed to strictly comply with the CCP 1010 notice requirements as a subsection of 128.7, it stated a date that never happened and never went forth. That cannot be said to be considered strict compliance with CCP 10. And in the Gallery Plus case, it says that respondent's purported notice served on April 25th, 2008. The document failed to specify when the motion would be made, rendering it fatally defective. And in this particular case, they did specify an original hearing date, but did not strictly comply with the hearing date of which they requested. And in this case, and in the other cases that were cited by plaintiff in the opposing papers, if you don't strictly comply with 128.7's requirements for notice and for the actual safe harbor provision, then the 21-day safe harbor never begins to run in the first instance. So by the time that the second motion for 128.7 had been filed 54 days later by the defense in this case, it's procedurally defective at the get-go because it was the 21-day period never began to run because the CCP 1010 notice was not strictly complied with. And the second issue that I would raise with the court would be as to the amount of the sanctions. So I'll defer to the court on whether you would like to hear from defense counsel first, or if you'd like me to just...
No, you may make your argument.
With respect to the amount of the sanctions in this case, as the court is aware, this is a limited civil jurisdiction case where the amount in controversy, I think, is less than $20,000. The amount of sanctions that have been awarded in this case are almost half of what the amount in controversy is. And the information that we submitted in our opposing briefs is we referenced the Lee versus Majestic Industry Hills case, and it says specifically that Section 128.7 is designed to be remedial, not punitive. This feels incredibly punitive under the circumstances. And what I can say is that there have been two previous discovery sanction orders in this case, one in the amount of $400, one in the amount of $800, which was issued by this court in favor of the defense and against the plaintiff. And in reviewing the amount of legal work that went into the law and motion work for the preceding orders that resulted in sanctions of $400 and $800 versus now where we find ourselves getting awarded $8,530.50, the first was the first that amounted in $400 of sanctions was 7 hours of total work per the declaration of defense counsel. The second order of sanctions of $800 per the declaration of counsel was six and a half hours worth of work. And in this particular declaration attached to this, they said there was 12.1 hours worth of work. So we've gone from almost a 2,000% increase in the amount of the sanctions awarded from the first sanction order to a 1,000% increase from this court's order with the $800. And we made the original motion for reconsideration in good faith. I understand the court's rulings and arguments that it disagrees, and I understand that. But in terms of the punitive nature of what it feels of these amount of sanctions, I would request that at a minimum the court reconsider to take the matters under submission to award sanctions in an amount that is more consistent with the prior orders of this court. And I'll submit.
Okay, thank you.
Thank you, Your Honor.
Yes.
In response to Mr. Poulter's arguments to point one, the court has a standing procedure that doesn't allow you to file documents within the 3-day period. That being said, we still strictly complied with the rules of court, the rules that Mr. Poulter specifically referred to when we filed this motion to begin with. The court then inadvertently took it off calendar, and when I called the clerk to inquire as to what the remedy was, the clerk simply told me to refile the matter, and that was what was done. And still, even after refiling the matter, pursuant to it being mistakenly taken off calendar, we still gave Mr. Poulter the additional time to withdraw, and he did not. So I think that the court's tentative ruling is correct. As to the second point, I'll leave that to the court and we'll submit.
And just one brief response. I was never provided any notice or information of anything that was just stated by opposing counsel. I was never informed via email or a phone call that the court had inadvertently taken this off calendar. In fact, the defense in late July filed a notice of non-opposition because they thought that I had failed to file an opposition to the first sanctions motion. But we had learned that there was nothing on calendar because there was a separate issue that I spent a lot of time on opposing. It was a motion for contempt. Spent a lot of time opposing that, and whenever I served defense counsel with my opposition, they said, "Oh, sorry, we forgot to tell you, we already took that motion off calendar." So I had my staff call this court and ask whether or not the first motion for sanctions was still on, at which point they told me it wasn't. So I never received any notification that has been represented to this court that they gave me extra time. In fact, it was the exact opposite. They filed a notice of non-opposition. And to the point, though, I think the case law supports that it doesn't matter. It says strict compliance. It's not substantial compliance. It's strict compliance with the notice provisions.
I will take the matter under submission. I need to consider both of your arguments. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you. All right, recess. Oh, is there another? Let me address the other motions. Not your case. Thank you. Western Funding versus Jose Vargas goes off calendar. An amended answer was filed. And Smith versus Gamboa Sierra. That parties submit to the tentative?
No appearances, right?
No appearances. So they waive argument. The court adopts this tentative. Silva versus J.P. Morgan, that was continued till October 28. On Gupta, I have I'll have that too in a moment. A slight modification before I adopt the tentative. I'm going to add the pre-filing order. Take me a minute. Thank you. All right, Fernando Garnica. All right, good morning. Has Mr. Garnica been sworn?
Yes, sir.
All right, Mr. Garnica, how are you today?
Doing well.
So, I looked at your petition and your claim of exemption and the supporting documents. Are you on disability now?
Yes.
Okay, and that started in July?
It's been 3 months.
And now is child support, are you presently paying child support?
Yes, sir.
Okay, and that's being deducted from the disability or just from,
Right now, yes, it's been deducted from the disability. And once I go back to work, then they'll take it off mine.
all right. You have a couple debts here that would not take priority over a judgment, but that being said, it does seem like the money's tight with all of these obligations.
Yes, it is.
Is there any amount that you could pay, or is it too tight?
I contact them, I try to settle.
Yeah.
Orange County Sheriff Department's holding $2,800 right now that was taken from my savings account and my checking account. So, on top of those $2,800, I was gonna borrow $4,000. So I offered them $6,800, and they wouldn't settle.
So that's a cash payment. What is it issue now? there's really two things that are at issue now. One is the amount of money that they would take from your check. Is the sheriff deducting money from the disability check?
No.
They're taking it from the paycheck, but not the disability.
When they got the levy, sheriff's department holds that money from my bank account.
I see.
The
So
only thing coming out of my disability right now is my child support.
I see. So this, I'm confused. So tell me again how much you believe they've taken?
It's I have a paper here. It's one account had $15,075.42, and the other one had $1,199.24.
And what do they take?
Both.
They took both accounts.
Yes. So I know my original amount, that the debt amount was about $8,000, and I tried to settle with it. The rest is interest. They didn't want to settle.
All right.
They asked me for $10,000 on top of the $2,800 that the sheriff's holding, but I don't have that much.
All right. For some reason, I thought they were garnishing, but this is a. Let's see.
The levy was just the one-time thing that.
Right.
I
Okay.
remember right here from the bank.
I see. Okay. All right. So when we look at when I look at a levy, I would ordinarily need you to trace the funds. Here, you have described your present income, and you say the property is exempt, and you cite Code of Civil Procedure Section 704.080 and 704.130, which are public benefit sections. So that means that you're saying that the money in the bank was from your public benefit or from your disability, but you've been getting the disability only for 3 months, and you had the accounts before that, right?
Yes. One's a savings account that I've been putting on whatever I can in there for my youngest child. She's a liver transplant, so she's 13 now. That's the one I'm paying child support for. So, just want to do a little savings for her.
No, I understand that part here, but all right, well, this paperwork's just a little bit confusing because it looks like the paperwork I ordinarily get with a garnishment. So hold on here. The lawyer on the other side asked for proof of things that I need to know if there was a garnishment. So I'm really thrown off here.
Yeah, they gave me a list of
Yeah,
expenses.
Yeah.
They wanted me to go a year back.
I know.
I have that here.
Okay, what I really need is where the money come from that went into the bank. So in other words, the deposits and withdrawals from the account that they seized in order to prove your claim. So you went for, there was a claim of exemption in November 2021, and that looks like that claim was, oh, your claim of exemption was granted and everything was returned to you November 1, 2021. That was Judge Kalra.
I've been trying to settle with them.
No, I appreciate that part. All right, I need to take a recess and look at this again because the garnishment of wages. I looked through it and said there's no basis for them. I would support your claim of exemption on wages. They should not take any money from you out of. But I was a little bit confused whether it was disability or based on your monthly expenses. I wouldn't. Now, I think that you've been misled a little bit because what they asked you to send was all this information about your monthly needs, but that's not even relevant to the decision about a garnishing. Levying your money that you saved. So the way if you saved money. It sounds like a wonderful purpose. You want to take care of your sick youngest daughter. You want to make sure there's some money for her. I can get behind that idea. I'm for that. I hope you can do that. The law is that you cannot. They can't take from you the money you need to put a roof over your head, feed your kids, feed yourself, medical care, the stuff you need, can't take that away. Everybody's entitled to at least have that. Beyond that, it's fair game, right? And even a beautiful purpose like saving money for your daughter. They probably have priority over that. It's not really, in a sense, it's not your money to save. It's their money to take. On the other hand, I could imagine you somehow. I can't. I don't know the answers for you. I just don't think it's fair for me to deny your claim right now when you've been misled about what needs to be shown. I'm a little skeptical that you can show me what needs to be shown, which is that this money that you put into the bank is what you claimed is that these are public funds, or like they're public benefits, like like Social Security or any kind of disability, that kind of money. They can't take that if you put it in the bank. They can't take it away from you just because you put it in the bank. It's yours whether you spend it or whether you put it in the bank. So I can deny the claim, or I can postpone it. Maybe you'll think of something.
I wanted to settle with them, but like I said, I was willing to borrow $4,000. So on top of what the sheriff department's holding, and I understand they didn't didn't want to work with me, but that's all I can get. Like, you know, if they would have said this, I would have still been in debt $4,000 for how I'm going to borrow this.
So what would you like to do? I'll deny your claim. Let them take the money, or you'll have to come back again and somehow justify to me why they shouldn't take it. I think your income is protected, whether it's your earnings and whether it's your or disability. I wouldn't touch that. But a savings account of money that's set aside for some purpose, even a good purpose, I don't see how that's protected. But I haven't thought about it.
I totally understand.
So shall I postpone it, or do you want me to deny it?
To be honest, at this point, I don't know what will be the best.
Well, so I see that there was a garnishment before.
Yes.
There was an order
To work.
previously where they held your money and it was not taken, right? They held it and your claim of exemption was granted.
Yes. So the sheriff department started paying me my money, partial payments back.
So I don't know why the judge did that. Did he say why he did that?
Who? I'm sorry.
So you, in 2021, you had you filed a claim of exemption, and it was the same sort of thing.
Yes.
It was a bank levy.
No, not in November. It wasn't a bank levy. It was
In 2021?
yeah. It was through my payroll through work. I was working at the time.
Let's see. Let me look at it again.
This is the first time I get a bank levy. This is the same person.
Right. Let me look at 2021.
So back in 2021, I had to do the claim of exemption because they were taking.
Yep, it was 20. They wanted 25%. I see.
I couldn't afford it.
Right. No, I see it here. So what that judge did what I would do about any sort of a earnings, which is I would grant the claim, and he granted the claim. But now they found your account and they're taking it.
And I understand that the interest it's going up. Even if we postpone this, it's still going to go up, and it's just more money that it's going to be hard to pay. So I did what I could, and I got a hold of him, like I said, and try to settle. But
Yeah.
I mean, if I can't afford it, I can't afford it.
Yeah. Okay. Well, I think.
This is back in 2014. This is what started 2014.
Yeah. No, I know. It's an old case.
Yes.
Okay. I think I have to deny your claim of exemption, but I don't know what else I can do for you. I'm sympathetic, obviously, to you.
Words. No, I understand. I understand your honesty. What would that put me at?
They take your account. They keep your money out of your bank account that they took.
And what will happen next?
I don't know how much, if that satisfies the debt entirely, or mostly. It's a lot of it, right? The writ is for.
It started with 8,000, and then it went up to 16 with interest.
Yep. Yes. So the writ of execution here says total amount due $16,577 is the amount that is due with interest, and the amount they have seized, I don't know what they seized. Do you know how much they seized?
2775 to be exact.
27,000?
No, 2,700.
They seized 2,700.
Yeah, that's what the sheriff's holding now.
That's the whole thing?
It was two separate accounts.
I thought there was another account with a lot more money that they took. No?
No. I have the paper here. One account had 1575 with 42 cents. The other one had 1226 with 80 cents.
1,226.
1,226.
Yeah. Okay. No, they take that towards the debt, and you still owe them.
Yeah, so I know I'm in a tough spot. They're just gonna. I'm not gonna see this money again, and
Right.
I'm still gonna owe them, and interest is gonna go up, and I'm never gonna be able to pay this.
Yep.
I was hoping they will settle with the 6,800, but I had no luck.
Good luck. This, whatever the several thousand that they took, the 16 and the 12, that's the subject of today's hearing, and so the claim of exemption is denied as to that. They get a little bit from you. It's a couple months' earnings, I guess. Okay, good luck. So the court will give notice of this. Oh, you can have this paperwork back.